And welcome back, everyone. Along with Andrew Whitman, I'm Richard French here. We've taken you through the morning portion of the testimony, the final testimony in the Intelligence Committee's hearings before we go to the Thanksgiving break here. And we're going to hear really the cross of the two witnesses, both Fiona Hill and David Holmes, when this resumes shortly. But first, let's bring in our guest right now, former federal prosecutor and University of Memphis law professor, Steven Mulroy. Steven, I thought, particularly yesterday, the testimony of Gordon Sondland, more than compelling. You really got to work at it to believe that this conversation and this thread of directives was not going up and down the food chain. He even named names as the folks that were involved. Was it just eye-opening, or did there create exposure? And the two names that jump to mind most of all, Secretary Pompeo and Chief of Staff Mick Mulvaney. Do these guys have to worry about something more than bruised reputations here?
It's a good question. I mean, I think you're right that the Gordon Sondland testimony really was a game changer. There had been all this talk up until then about, well, there was no one that had direct contact with the president, and it's all hearsay and speculation. And Sondland just laid it on the line, like you said. He's dealt directly with the president. And there was a quid pro quo. He said it explicitly, and he said that everyone was involved at all different levels, including the high-level people you just named, Mick Mulvaney and Mike Pompeo. As to their jeopardy, clearly Sondland implicates them. And there really doesn't seem much reason for him to lie about this. I think that the pressure for them to testify is going to increase. I think that if they are ever inclined to testify, then they're probably going to make sure that they don't get a perjury conviction by going ahead and telling it all. But I think what they may try to do to avoid any potential jeopardy is just do everything they can to avoid testifying.
To that end, and obviously Bolton comes to the top of mind, given his constant references and his descriptions of not wanting to be involved. In fact, even directing Hill to tell the NSC lawyer, make it clear, I don't want to have anything to do with Rudy and Mulvaney and this drug deal they're cooking up. He described Rudy Giuliani as a walking hand grenade and the rest. What has to happen, Steven, to compel these folks to testify? It seems that some want to. They're looking for clarity from the courts, while others just ignore it outright. Who can make who talk, and when will the courts clear it up for anybody that's, in no man's land?
Well, the House does have subpoena power, and they can issue a subpoena, which is the same as a court order. They are legally compelled to testify. The problem is that many Trump administration officials, acting on the direction of the White House itself, have simply refused to comply with subpoenas. And then the next step would then be for the House to go into court, as it has done with some previous subpoenas, to try to enforce that. The downside is, though, that court process takes a long time. It can take months, if not years, to get completely resolved. And the House Democrats don't really want to wait that long. So that's the dilemma. I think that the House Democrats have made a calculated decision that they have enough evidence with what they've got, so they're not going to put everything on hold and gum up the works by chasing these court victories over subpoenas, even though I do think that they've got a pretty strong legal case that they should be able to compel these people to testify.
Stephen, it's Andrew Whitman. I just want to ask you about one of what I thought was the more effective Republican pushbacks on Sondland's testimony yesterday. At one point, one Republican congressman got Sondland to admit that, and here's the quote, "Nobody on the planet told you that aid was tied to the investigations." And Sondland came back and said, yeah, I pieced that together based off everything. There was a lot of reaction like, aha, that shows you didn't hear it directly from Donald Trump. You're a former federal prosecutor. You've forgotten more about the law than I'll ever know. Is that how this works? Do you have to hear it straight from the horse's mouth, or what we heard from Sondland good enough to prove that Trump knew?
You definitely don't have to hear it from the horse's mouth, as you put it. So in a typical criminal prosecution, you don't have to get somebody testifying that the defendant personally told them everything that was going on. You know, personally admitting to all of the criminal acts. You are allowed to make reasonable inferences from the surrounding data. And here we have Sondland testifying that Trump repeatedly brought up the investigations in conversations with him, that he told him to talk to Rudy Giuliani to get direction on how to handle these things, that Giuliani was telling him that the White House meeting certainly was a quid pro quo situation, that no one could explain to him, despite repeated inquiries, what the reason was for the holdup on the aid, and the fact that they were preparing this press statement for Zelensky to make, referring to the investigations before the aid was going to be provided. I think that, plus a lot of other communications he had with other individuals that he's named, I think it can add up to a fair inference that, as Mick Mulvaney himself admitted, that the military aid was tied to some of these investigations, and that President Trump must have known about this.
You know, Stephen, it's interesting because we went through the chain of events and the multiple players that were involved in the timeline of this. And unless, and I don't want to ruin this for anybody at home, you're waiting for the Tooth Fairy or the Easter Bunny to appear before our eyes, Sondland was put on this, and career professionals whose portfolio included Ukraine were taken off. Aid directly withheld. Meetings canceled, including with the vice president. Rudy Giuliani sent directly to the Ukraine at the behest of the president as his personal attorney, carrying on conversations. Multiple players, including the people we're hearing today, Bolton and others, raising not only red flags, but doing it, at volume 10 about what was going on. The phone call that was witnessed by not one, but two people as to the conditions for the aid that they heard firsthand. My point is, I still don't believe, because this is not a criminal prosecution at the end of the day, this is a political exercise, that 20 Republican senators haven't been moved enough, whether they believe he did it or not, to say, if it goes before them, yes, a high crime and a misdemeanor was committed today. So to that end, because this is political theater as well as it's also, an actual inquiry, what else needs to happen? There's a few things I think might be additive that could change minds. One would be, I'd love to hear the entire conversation that the president had, not the redacted version with Zelensky. I'd like to know what else might be on that server, and if we have to have the proper people or the equivalent of like a FISA court to actually go through it so it doesn't compromise national security, but maybe a call with Putin that apparently sitting on there would be additive to this conversation. I believe, in addition, finally, if we get some resolution on these tax returns, if you can make any linkage whatsoever where there might be some invested parties and there could be any financial component to this conversation to make some sense of the inexplicable relationship and the coddling of Russia that we've seen time after time. But it looks like the clock is against me for all of those things to get this thing done in the next 90 to 120 days. Lay out an argument. You're now the chief prosecutor. You want to lay out the best case to the Senate to make this ultimate decision. How practically can you get your hands on things that can give it the necessary color and context to make it really hard to say there's no gambling in River City?
Right. Well, so if this were a normal criminal prosecution, the next step would be obvious. Now that Sondland has laid it all out as he did, and he named Mulvaney and Giuliani and Pompeo as people who were principally involved in this and had direct contact with the president, the next approach would be to subpoena Giuliani and Pompeo and Mulvaney, and not to mention Don McGahn maybe, and get them to testify about these things. This is an unusual situation, though, because the Trump administration is just instructing people just to ignore the subpoenas. So where else do you go for the evidence? Well, you've suggested a couple of things. The lower courts have ruled that Congress is entitled to the tax returns. There are other things, other files, like you mentioned, the unredacted version of the phone call that might be worth, investigating. But I really have to say, Richard, at this point, I think that there is sufficient evidence already for people of fair minds and who are not politically biased to conclude that it really was the case that both the military aid and the White House visit were conditioned on the two investigations, and that Trump, at a minimum, knew about it, if was not directly instructing it. And just the transcript of the phone call, in his own words, where he kept asking about those investigations, and the July 25th phone call, added to all the other evidence we just discussed, I think is sufficient to make that reasonable inference.
You know, the Supreme Court's going to obviously decide whether or not they're going to take the case relating to the tax returns and the 8 years of those returns. Somebody made a point to me to say, you know, the Supreme Court has not always taken a measured approach in terms of being not cognizant of timelines, most notably Bush v. Gore. They expedited a ruling here so we didn't sit in limbo not knowing who our next president was going to be. Given the reality of the calendar, could the Supreme Court decide, and can you point to any other examples where I can say, listen, obviously this is a critical window of time. There's numerous questions about whether or not the subpoenas can be enforced, whether or not the returns should be available to the probe here, whether or not as mentioned before, the contents of the server should be under inspection. Could the Supreme Court, if they chose, decide to give an expedited ruling on the bundling of questions before it because there's an obvious national interest that they don't want this impacting the 2020 election in real time?
The Supreme Court most certainly has the discretion to do precisely that. There's nothing that would stop them from doing that. However, in the other example you cited, Bush v. Gore, there were actual legal deadlines. There was the certification deadline. There was the so-called safe harbor deadline for getting final certification of the state's presidential election returns before Congress was supposed to convene on January 6th and certify the results, et cetera, that definitely made a compelling legal case for the court expediting review. Here, the considerations are maybe nonetheless compelling, but nonetheless more political in nature. We don't want the impeachment hearing dragging over into a presidential election year and the presidential primaries and, God forbid, the general election. Those are compelling, but they're not legal in nature. So the only thing I could think of that would be plausible in terms of arguing that the Supreme Court needs to expedite review on all these issues is if the House did vote to impeach and an actual Senate trial was scheduled and one or more parties went to the court and said, we believe this evidence is going to be material to this very trial that already has a beginning date, maybe then you'd have a good legal argument for getting the court to expedite review. But with this particular court, I would not hold my breath.
I'm not going to. Last question from me. You've already said what I think most legal scholars I've heard is a compelling argument and evidence layout has already been presented that a high crime and a misdemeanor could have committed. And just a reminder for our audience, the Founding Fathers identified foreign interference in our elections as such an example. It's not like people have to divine, what did the folks think back when they set up the country? Probably didn't have Ukraine on their mind, but they certainly had an idea here. They didn't want foreign involvement in our own elections as to compromise the integrity of it. But I have a broader point, and that is, Steven, if this goes unchecked, if the message at the end of the day is, yeah, you withheld aid, because you wanted dirt on an opponent, but whatever. Without hyperbole, we're now saying the checks and balance aspect of government, that the legislative branch has a role of oversight over the executive branch. And that enumerated power of impeachment, not to be taken lightly, but was there for just these kind of things. We are, whether people want to admit it or not, in this insane news cycle we live in nowadays, we are setting a new marker down that the president basically has unchecked power. And You know, as the president says, he can do whatever he wants, including shoot somebody on Fifth Avenue, and there is no consequence as long as he calls Pennsylvania Avenue home. I know maybe I've dressed it up with some language, but at the premise of it, if there's not a punishment for these actions that seem to have been proven, we are going to face a consequence as a country.
Yeah, so I mean, I think any fair observer would have to say that if you are convinced that Trump did in fact try to use either the military aid or the White House meeting, either one, as leverage in getting politically motivated investigations, and I think the evidence is pretty strong that you can make that inference, then if there's not some kind of consequence, and you can debate, is it actual conviction and removal or simply impeachment or censure or something, but if there's no actual consequence that flows from that, then there's a real danger that we're defining deviancy down, that our standards are getting lowered. This will become the new normal. This will be considered to be part of the game. And it's particularly urgent right now because we are going into the next election cycle. And as Fiona Hill's already warned us, there are continuing efforts to interfere with our next election cycle. And this defining deviancy down means that this could happen all over again in 2020.
And seemingly without a lot of concern from the administration, who has done little, if anything, to try and secure our election integrity for the next go-round. But Stephen, great job as always. I really appreciate the time. Thank you so much. Steven Mulroy.
Thank you. Thank you.
All right. Andrew and we're going to take a real quick break here as we go out. This is a live shot of the hearing room where we expect the hearings will resume. I lied, not a live picture, but be for Fiona Hill and David Holmes. It's going to be the Republicans' turn to ask some tough questions. Andrew and I back right after this.